Well, good morning, everybody. My name is David Wesley. I am the presiding judge of Los Angeles. You know, I just wanted to comment. I was watching the session you just came from, and he was talking about technology and the young people with technology. And we recently did a seminar about that. And one of the things about this technology is that we fear that young people are losing the ability to have conversational competence. If you look at them, they're always texting and shorthanding. And we worry that they can't communicate. So today we're going to have conversational competence. We're going to talk to each other about what we did in Los Angeles. But I want you to think about that, because we worry that kids, as they get older, won't be able to work in groups and converse with one another unless we force them to talk to people. So what I'd like to do today is provide you a little history, tell you a little story to put in perspective about how we as judges and administrators in Los Angeles learn to appreciate and use each other's skills and become a team in a time of crisis. Before I do that, however, I want to read to you a speech I gave to all of our court managers a few months ago. It starts here. I've been doing a lot of reading about the great challenge in balancing judicial autonomy and court administration. One article pointed out that each judge is an independently elected or appointed public official, and that they value above all else their independence and personal autonomy. Don't I know it as PJ of LA? And while this independence and autonomy is essential in the area of decision-making, applying that same autonomy to administrative matters makes it difficult for a court as an organization to function efficiently and effectively. So that unless judges can give up some of that independence and power, the effective administration of the court is compromised. The example they gave in the article I read is a 7-judge court. It will either be one court with 7 judges or 7 courts with 1 judge each. In Los Angeles, it would be one court with 554 bench officers, or 550 courts with 1 judge each. We have opted for one court with 554 bench officers. So the key is to strike that balance between judicial autonomy and effective administration. How do we do that? Well, this article put it nicely, and sometimes judges have to remember this, and I know judges that do not remember this. The words judge and court are not synonymous. The words judge and court are not synonymous. I went on to point out that for many court users, they never see a judge. And it is the impression that our employees and managers leave on the public that is the face of the court. This last year, we all came to realize that many of the issues the court faces are not strictly legal and can be solved or addressed through the knowledge of law. There are organizational issues that require expertise in areas like case flow management, information management, document management, financial management, human resources, procurement, technology, and I could go on and on. Success in these areas requires a partnership between judges and managers and a recognition of each other's expertise. We soon came to realize that in implementing our crisis plan, there are few, if any, judicial issues that do not have an administrative consequence, and few, if any, administrative matters that do not ultimately affect the work of the judiciary. I ended by reminding all of our managers that we are a team and we are all in this together. On reflection, I believe the genesis of these remarks was our struggle to survive as a court after a series of devastating, and I mean devastating, cuts by the governor of California to our court. And the remarkable dedication and talent of our employees and our managers and our judges working as a team with what we call a shared consciousness of purpose to accomplish a massive movement of cases and consolidate the functions of our court. So today we're going to condense what we did in a little over 6 months into a little over 1 hour. Thousands and thousands of hours of work to accomplish what we did. So I think we're going to look at the start of this and then take us on forward. So, let's see if I skipped the slide. Nope, okay. So the story begins in 1997 and 1998, two important events that set the stage for the unprecedented crisis that hit our court. In 1997, our legislature passed the Trial Court Funding Act in California that shifted the court's funding from the local counties to the state. The goal was to provide a stable and adequate funding for the courts statewide that was not dependent on the wealth of any individual county. California has 58 counties. As you will see, that goal failed. In 1998, Proposition 220 was passed. It unified all of our limited jurisdiction courts, our municipal courts, and our general jurisdiction courts, our superior courts, into one court. In Los Angeles, that meant that 24 separate municipal courts with 24 separate operating systems were merged into one superior court. So 25 courts became one court. We finished that consolidation in 2000 in Los Angeles. We call it a unification at that time. When we finished in 2000, our court had 58 courthouses across Los Angeles County, which is 4,000 square miles. We had 596 bench officers. We had about 6,000 employees, and our caseload was roughly 1.5 million cases. The court's strategic plan at that time was to be the largest neighborhood court in the country, providing a wide variety of services to the public close to where they lived. We were very successful achieving that goal. We had 12 districts, each with supervising judge. We had multi-purpose courthouses run on a coordinated, decentralized management system, flexible enough to meet the needs of any local community. Now, I want to note, Los Angeles has 88 cities, so when we're talking about local communities, there were a lot of them. We thought, building for the future. We had individual IC courts, that means civil courts with judges handling the case from start to finish, a system that we liked and found efficient. We had ADR, alternative dispute resolution programs, problem-solving courts, self-help centers, meeting the needs of tens of thousands of self-represented litigants. But then in 2002, the first hint of trouble for our newly unified state-funded system. What we call in California the dot-com bust. Trouble in Silicon Valley that impacted the state's economy and began a series of cuts to government services, including the courts. But although we laid off some employees, literally for the first time in the history of our court, and closed a few courthouses, our delivery service was not greatly impacted, and we remained largely a neighborhood court. Then the bubble burst. Fiscal year 2008-2009. The governor and legislature began a series of cuts to the court funding that eventually resulted in 4 waves of layoffs and other non-salary spending cuts. The first wave was a hard hiring freeze, letting attrition take its toll. But we were still a neighborhood court. The second wave was 329 clerical positions, but we were still a neighborhood court. The third wave was a 10% across-the-board cut to all districts, closure of 56 courtrooms, elimination of court reporters in our civil courts, closure of 10 informal juvenile traffic courts, the layoff of 10 referees and their staff, and a voluntary separation program for commissioners and court reporters. By the end of the third wave, we had lost over 800 employees, yet we were still a neighborhood court. But the cuts kept coming, and the fourth wave, fiscal 2012-2013, required us to reinvent our court. That is what we're here to talk about today. The final cuts to our budget left us with $187 million less than we had to operate our court in 2008. We realized that for the first time in our court's history, we simply did not have the resources to support our structure and the ease of access and multiplicity of services with decentralized management that were inherent in the neighborhood court concept. We had taken as many across-the-board cuts as we could, and we still had a $50 to $85 million structural deficit in our budget that year. So we turned to our supervising judges in every discipline: juvenile, civil, family, criminal, probate, and I asked them to present plans to the court's budget committee. And the budget committee, made up of judges, reviewed the recommendations of the supervising judges and in turn created a plan to consolidate services. I should say that there was administrative input into that plan also at that time. The plan was then submitted to and approved by the court's executive committee and the full supervising judges committee in November of 2012. And it would be my job to implement it when I took over as presiding judge at the end of December. Lucky me. I then worked on the plan with Judge Jones and Deni Butler and a few other judges and administrators and presented it to our new supervising judges. We change our supervising judges in December of each year. They can stay for 2 years, they can stay for 10 years, but we pick new ones. And so in late November of 2012, it became a staff reorganization exercise. That's what we handed out to you all. So I'm going to take 1 minute here, and if you haven't had a chance to look at it real quickly because it'll set in your mind the kind of things that we had to do. You might have questions as to why we asked for certain information on that, and I'll be glad to answer that as we move along. Imagine you're an administrator who has to come up with all this information in a few weeks. And as you're looking at it, remember that as we got this information, we had to digest it and figure out how we were going to use this information. We had an idea of why we needed some of it. All right, I'm going to move on. So we gave this out to our supervising judges. They met with their administrators, and they gathered up this information for us to come to a meeting on December 7th of 2012. I thought that was a very good day, December 7th of 2012, Pearl Harbor Day. It was during that conference that we reviewed all of the information provided from each of our 12 districts and talked about how we were going to do this. And by the way, failure was not an option at this meeting, and it was not, oh, we can't do this. It was how we were going to do this. In fact, in that exercise, I said, if you find that there's something difficult here or a problem, don't come to me and say we can't do it. Come to me with a solution. Because we didn't have a choice. This was not brought on this court by choice. We didn't have the money to function anymore. So what we required, what we wanted to get out of this conference was what retired General Billy Crystal called a shared consciousness of purpose, achieving the goal of implementing what we now call the consolidation plan. This became our single objective for the next 6 months, our shared consciousness of purpose, to implement this budget plan and achieve a balanced budget. We had to balance our budget. Well, 6 months later, our court looked different than the neighborhood court we had in 2000. We no longer had 58 courthouses. We had 38. We no longer had 6,000 employees. We had 4,200. We no longer had 596 bench officers. We had 550. We no longer had 1.5 million cases to handle. We had 3 million cases to handle. We abandoned our principles of being the largest neighborhood court system with a coordinated decentralized management system. But we kept and maintained other principles that guided our consolidation. I like to say it was a principled consolidation that we had no choice but to make work. We had to meet our constitutional requirements and statutory obligations. We wanted to maintain access to justice in all litigation types. By the way, California, a lot of courts were in crisis because of the budget, and some decided they were no longer going to do small claims. They just stopped doing them. I don't know how you can do that, but they did that. We decided we were going to keep courts available in every category of case. We wanted to use most effective use of our bench officers. So we had blended calendars where one bench officer might do unlawful detainers, small claims, and traffic. And we found that that was not an efficient system for us. And so we'll talk about how we eliminated those blended calendars. And we had to have a fair and even distribution of the resources within case types, so we couldn't give one judge 4,000 cases and another one 500. We had to equalize the caseload, and we tried to do this by keeping most cases within district, which was not easy. Also, at this time, I had to create a team to do this. So let me just ask, Judge Jones and Deni Butler, I was the PJ, of course, and under the rules of our court, I had the authority to just say, do it, and cut it. But I didn't have all the knowledge, to be honest with you. And so I knew I needed help. Judge Jones, why did I drag you out of the writs and receivers court and make you the supervising judge of budget planning and implementation, a position that didn't exist before?
More interestingly is, why did I say okay? We had been working as a court collectively on all those various reductions, and we had acquired a little bit of an appreciation that we were now critically inefficient in certain areas, and that we needed to come about a whole new way of thinking. And I think it was in part because of the past experience that I'd had working with the others on all of these other changes and all of these developments that I was certainly identified as someone who enjoyed these issues and claimed a certain degree of proficiency in them, although I was soon to learn I was ignorant on most fronts. And so it was critical. This was a new opportunity. We had to rethink how we were doing business in the courtroom as well as in the rest of the courthouses. And so it was not something that could be done either by the judges or by the administrators. It definitionally was a problem that presented itself with having to have a consolidated or combined solution. So I don't know why I said yes. I was smoking something. I had actually...
I'm very persuasive. I have to say, I'm very persuasive. That's why she said yes.
Yeah, that was it. I had made the mistake of getting a master's degree in public administration, and that thereby qualified me as being the judge who would step into the breach. But I quickly inveigled Deni to join in the efforts.
So, Deni, why'd you get dragged in?
I think I was the last woman standing. I'm not sure. You know, the judges came up with this plan, and they needed to reorganize their work, and they recognized that, and they really reorganized their work. But they also recognized that it was only going to work to the extent that they had the right staff in the right places to support the new structure. And so Judge Jones and I really can't remember how this happened.
We can't. We tried.
But
it's a blame.
There were teams that were formulated. A number of people that were on those teams and led those teams were in this room. And on each of those teams, there was a staff leader and a judge leader. And then there were other people on the team across our IT departments, our facilities departments, other areas that were affected. So if we were closing a courthouse, we made sure those people were on the team. And they did 99.9% of the work. And they can speak to really a lot of these things. But I will admit that when they first came out with the consolidation plan, and I read that document and the plan document, I thought, oh my, this is very aggressive. I'm not sure we can pull this off. And then I quickly realized, oh, geez, I got to live with however this turns out, so I better get on board. And so that's kind of how we started working together. It was really that fluid of a situation. We were going to do this, and we needed to put the best face on it possible.
And I think when you see the scope, you'll realize that we all felt a little bit of pressure. We had 6 months. Our budget, like I told you, I came into office actually January 1st, but we transitioned in December. And I had this huge budget deficit. And so we ran out of money July 1st. So either we solved this problem by July 1st, or we were a court that was broke, and we were not going to be open. And so we knew we had to do something. So our first plan called for closing 10 courthouses and moving all the cases, reducing the staff, reassigning the judges. We ended up only totally closing 8 of those courthouses. 2 of them, Beverly Hills and Catalina, remained open, but not fully open. So I'm going to turn to Judge Jones and Deni. Why did we not close all 10 courthouses as we originally planned?
This is a perfect.
Use the mic, Ann.
This is a perfect example of judges can only get so far. So we had come in with this very well-considered plan on paper where we were going to take one of the busiest traffic courts in the county of Los Angeles and distribute its work to a court that was geographically closer, and then another court downtown. And it was within maybe the first 2 weeks, as part of the traffic team's listening tour, where you'd go out and you'd walk the buildings, you'd meet with the justice partners, you'd have all the members of the team there, that we physically saw that the courthouse to which half of this traffic work was going to go was so small, it had no access to the second floor, which was the traffic department, and so antiquated in its configurations and its capacity that it had no way to take a fraction of the work that we were, by the plan, scheduling that was going to go into that courthouse. So quick like bunny, we realized that the plan, and this was kind of the beauty of the plan had to be changed. The plan, there were principles that were inviolate, there was the need to capture the savings that was inviolate, but the configurations, the designations, those were all subject to what we would call tweaks. This was a tweak, so we said, okay, we all originally planned that all this work would go into 2 courthouses. It can't go into this second courthouse. It's not physically possible, literally walking the corridors, seeing the width of the corridors, and knowing the number of people that would be coming into that building. It could not hold them. We did not have the security or the capacity. We needed to come up with another plan. And so the original decision to entirely close the Beverly Hills Courthouse was changed so that we would keep a single traffic arraignment department, and they would be able to handle the arraignment traffic.
118,000 cases. One judge, a senior judge, volunteered to do it.
And so, while it is not a thing of beauty, I must admit, it worked better than putting it in Santa Monica. And so we switched and abandoned our plans. Also, Beverly Hills had a very adequate lockup facility, and at that time we were closing courthouses and were concerned that our lockup capacity was being reduced significantly in that part of the county. And so that was a big enough concern that it justified keeping Beverly Hills open, in part to enable us to have a lockup facility that was still
And for those of you that don't have a criminal background, what we look for when we're planning for criminal cases is lockup capacity, especially in times of crisis. Forgetting court crisis, if you have a riot or you have something goes on and they arrest a lot of people, you have to have lockup capacity in order to process those cases. And we had closed most of our lockup capacity on the west side of Los Angeles. So we looked at Beverly Hills, had a good lockup. We figured, well, if we're going to keep one judge there, we get to keep that lockup open. And that gave us lockup capacity. So what you're looking at here, think about your courts, if you're from a different court than Los Angeles, affects about 3 million people, just this group right here, about 3 million people. We redirected over 400,000 filings just from this group right here, and eliminated about 250 employee positions and 30 bench officers working in these locations. So we moved most of the bench officers, but we eliminated some of them. So that's the beginning of the plan. I would say also, when we're talking about why I drafted Judge Jones, so I'm the presiding judge. I had this very ambitious plan to do in 6 months. When you're from a county of our size, of 88 cities and 44 police departments and another 15 or 20 police agencies that feed us cases, and you're going to do a plan like this, you have to sell it. You have to sell it to the bar, you have to sell it to the judges, you have to sell it to the supervisors and the city council. You have to sell it to the politicians that work in our area. That's not the judge of the administrators, that's the judge of the judge's job. That's my job. I knew I was going to be out selling this, explaining this, arguing with people about this. At the same time, we had to be moving forward on it. I couldn't do all that, and that's why I needed Judge Jones to do it. So we met every single day, but while I was out trying to sell this program, and also going around and talking to the employees and encouraging them, because I knew this was hard. This was hard on the judges, this was hard on the employees. Change is hard for all of us. Any kind of change, and this wasn't just change, this was dramatic change. So we also closed 12 criminal courts and redistributed those cases. We had never closed a lot of criminal courts before. This was a big deal. We reconfigured our central arraignment court, which is attached to the jail. We moved 20,000 cases from there to our East Los Angeles court, even though we had no housing for the prosecutors there. We, by the way, have our district attorney's office, and then we have 17 other prosecuting agencies in Los Angeles. So this particular group of cases was prosecuted by the LA City Attorney's Office. They had no housing at this East LA courthouse. And so we wanted to move those cases. Why did we move those cases? Because at the same time that we were being cut, California adopted, well, the governor adopted something we call realignment. And what he did is he changed the definition of felony, and I'm not going to go into a long explanation of this, but he realigned cases. We all of a sudden had parole hearings and what we call post-release community supervision cases. These were all executive functions before. Now they became the court's problem, and we had no place to do them. And we had no protocol for it. There was no protocol, it was just dumped on us. So I was working statewide on the protocol on this. At the same time, we were trying to figure out how we were going to handle these cases. Administrators had to tell me how many administrators they needed, and the sheriff's department said, we want to do these at the central jail where you have a court, so move everything out of there because we don't want to move this population around the county of Los Angeles. This was all going on at the same time. We were just trying to figure out how to stay on top of the budget cuts. So we did this, and we moved those cases. And I think the sheriffs were happy with us, but the city attorneys were not. And it was about 9,000 new hearings. 9,000 new hearings in that courthouse. I'm going to move in traffic down here. I said we consolidated from 26 to 18 locations, moving hundreds of thousands of cases. We couldn't move any more to our central traffic court, which was downtown, because it already had 375,000 cases. And so we realized that we couldn't dump any more work into that court. There weren't enough bench officers in that court to handle any more cases. That's another reason why we chose to keep some open. We also closed a juvenile court called Canyon Courthouse. That created some political issues in an admittedly underserved area of the court, and it was kind of nasty. And then we also laid off 12 subordinate judicial officers, and from a presiding judge's position, I was a subordinate judicial officer before I was a judge, before I was the presiding judge. That was an emotional issue. So all of our referees that sat, and I started out as a referee on our court, and then a commissioner, then a judge, all of our referees that did informal juvenile traffic court were laid off. And these people had left the practice of law and were working in our courts, and we laid them off. And we transferred that workload, about 65,000 cases. We divided it up. The traffic cases went to adult traffic. The other 35 cases went to probation, and we said, they're your problem, figure out what to do with them. We closed a dedicated adoptions court at our children's court, which is a a centralized or consolidated court that does all of our dependency work, and we transfer that caseload of adoptions cases to all of the dependency judges in that court, giving them extra work. In family law, we moved 10,000 civil harassment hearings to our family law, an increase of 15% of their caseload. It also requires a bailiff and raised other issues. Judge Jones, you want to address any of those issues that we created a problem for us?
We did. We had the problem with civil harassments, if any of you are familiar with that subject matter area, is that many of them may seem inconsequential, and then there's the incredibly scary one where someone's life is in danger. And to have a bench officer with neither a bailiff nor a court reporter, which was our civil configuration at that point, seemed intolerable as far as exposure of the judge and the security concerns. So we asked family, who wasn't busy enough, to take over those cases because they have bailiffs and court reporters. And so it was a simple question of trying to get the staff configuration in the courtroom to go with the work, even though at that point asking family to pick up one more thing was just an unconscionable request on our part, but nevertheless it was made. In a handful of locations where the family law calendars simply could not accommodate it, we actually put it in courtrooms that still had bailiffs in them, although they didn't have court reporters. We put them in traffic departments because of the need for the security from the bailiff. But it was, and continues to be, a very difficult part of the consolidation plan. We centralized restraining orders in the downtown courthouse, which is a lovely, efficient model, but unfortunately, in a lot of the outlying districts, you don't have those economies of scale that you need to have a centralized location.
And of course, when you add the civil harassment caseload, which has statutory priority in California, to the family law cases, it inevitably encroached on the length of time it takes for a custody or a paternity dispute to be resolved. And so it lengthened the time in those courts, something that I actually anticipated. Any of these moves were going to lengthen our pendency in our matters that were before the court. In probate, we moved from 8 probate locations around the county to 1. We moved all of those courtrooms and all of those caseloads to our central court, the Moss Courthouse. A lot of cases. Deni, Butler, any unique issues? Judge Jones, I want you to talk about why we have gavel will travel.
So probate was one of those things that was a piece of somebody's job out in the districts and a couple of full-time bench officers in Central, and there was a thought that if we consolidated it all in Central, we'd get some economies of scale and use less staff. Maybe that turned out to be true, maybe it didn't, maybe that's still open for debate. But it did free up resources in those places where it was a piece of a judicial officer. And so it was part of the bigger puzzle that needed to come together with these many, many moving parts. But one of the things that was recognized early on is that there are people that have mobility issues, conservatees, people with other health issues that are having guardianships, conservatorships. And so we created a program, actually the judges created it, called Have Gavel Will Travel, where the judge basically goes out and rides a circuit on some kind of periodic basis, depending on the need, to address those issues in the location where it's just too hard for the people to get 30 miles, 40 miles, 50 miles to the downtown courts.
And we have video court call that we're experimenting with, which means they can make appearances from their district, and it comes to the judge in the central district. We're working with that. The Have Gavel Will Travel program was a success, and actually we're having fewer and fewer cases where they're having to travel because other accommodations are being made. But it was an ADA issue. We wanted to make sure we were on top of it, and so that's how we solved that. There were about 60% of the cases that were being done in the central district. So what we did was, in those other courthouses around, we moved 40% of the caseload for probate in the county into the central district. We had some computer issues with respect to that. The logistics of that were quite difficult. We've just shifted that court, and Deni, if you want, I don't know that much about it, but we just shifted that court into a paperless court, basically.
So on a bigger scale, that is our first court that's gone paperless. But while we were doing all of this consolidation and moving cases around, we were a little behind on our technology. And so in probate alone, I think there was 10 different databases that people were working in. Civil was along the same lines. I'll get to that in a minute. And so that added to the challenge. But with the consolidation, we were able to put everything into one database, and they have recently gone paperless. We do not have electronic filing yet. That's our next adventure. And we are looking to update computer systems as a whole, because the 10 databases that went into one is great, but it's still a 25-year-old case management system we're working with.
Yeah, we are the largest court in the country. Our criminal system, which 290 judges in my criminal division, handling about 60,000 felonies and 500,000 misdemeanors every year, work on a system that is COBOL.
I said a
That's-
little behind.
Okay?
That's our better system. What are you
Our
saying?
civil system
That's our
is
robust one.
sustained DOS. So when we talk about the problems that we had doing these things, these are the systems that we had. I'll give you, I'll go back to traffic for 1 minute. We've completed this system now, and I travel around the county, and I'm in one of our courthouses, and I see a long line of people, and we do this. I have 38 courthouses, and I visit them. And I said to this man in line, what are you here for? And he said, I'm here to pay a traffic ticket. I said, let me see it. And he was in Van Nuys, and it was a Chatsworth site. He can't pay that ticket in Van Nuys. He'd been waiting 2 hours in line. I had to tell him that. They didn't know who I was. I just was probably like a clerk out there. And as soon as I said to him, you have to do that. I've been waiting 2 hours. I understand, sir, but you have to pay that in Chatsworth. Everybody else in line, what about me? What about me? You know? And they had to come rescue me. But that's one of the problems that we faced when we did this. There were so many issues that we as judges were unaware of. It's not my business to know that. It is now, of course, but it wasn't then. And so I've learned a lot. Okay, so there were huge changes in our civil practice, huge changes. And again, we have probably the largest, I know we had the largest litigation, county bar litigation section in the country. The litigation section of the county bar alone has 26,000 members. We have a huge county bar. And now you're affecting the way they practice law, and we really affected the way they practice law. So, Ann, if you talk about this just sort of briefly, what we did in civil, so they understand the magnitude of the change.
Going back to our principles of this design, one of them was that we would meet our constitutional and statutory obligations. With the exception of unlawful detainers, there aren't any in civil. And so we knew that if we had to break something and make it very, very slow, it could be civil. It could not be criminal. It ought not to be family or probate, but it could be, frankly, civil litigation. We didn't say that to the lawyers, but that was the thinking. And we also appreciated that we had a very lovely judge-intensive system where we took care of the case from birth to death, whether it needed it or not, because the California Rules of Court said we had to, and we did it in every case, limited and unlimited. With the exception of small claims, we paid so much judicial attention to these cases, you can't believe it. We had them in because they hadn't filed proofs of service. We had them in for case conferences. We sent them to mandatory mediation. We had a post-mediation status conference. We talked their ears off until they capitulated and settled. But we managed our cases very intensively, and it was very successful. More than 80% of our civil cases were resolved within 2 years of filing. That's what the California Administrative Office said we should do, and we did it, and we were all very proud of it. Knowing we had to break this system was excruciating. So we tried to do it in ways that made the most sense. We isolated those cases that we believed as judges didn't need that kind of attention in order to resolve. So we took cases like personal injury cases, where we've now discovered the lawyers didn't want to come in 57 times to talk to us. They wanted to be left relatively alone. And we centralized those into 3 master calendar departments all in one courthouse. And those cases would be treated somewhat lightly rather than actively managed. We also isolated limited collections cases, another group of cases where we were fairly confident the lawyers wanted to be left alone. Most of those cases, more than half of them, proceed by way of default. There is no need for active supervision of the litigation. We took over 80,000 cases and put them into 2 courthouses with a single trial, with a single master calendar department in each courthouse. We also then, with those cases that did have statutory requirements, we had small claims and unlawful detainers, we took a model based on our largest courthouse and what an efficient court could do within the statutory period, divided it by the total number of cases, and then positioned those courts strategically in geographic locations throughout the county and specialized in those functions. So we have unlawful detainer, what we called hubs. We have small claims hubs. We have collections hubs. We had a single department downtown that did all non-collections, limited civil cases for the entire county. We quickly accepted Lancaster because it was so far away from downtown. But for the most part, these matters were centralized in a single court. And from that, we could obtain enormous economies of scale in both the administration of the cases and the ways in which the cases were handled. In order to do this, we actually had to break that California rule of court. And being judges, we didn't really want to break that California rule of court, so we decided we needed to change that California rule of court. And among the many things that were going on at the same time with all of these monumental movements in cases and case management techniques, we also had to get the rules changed, both our local rules and our California rules of court, in order to be able to accomplish this. But we eventually ended up with specialized courts in limited numbers of locations that when and if the case needed to go to trial, could be tried in dedicated trial departments. That allowed us to remove a lot of the staff resources from those courtrooms. We no longer accepted filings in those courtrooms, we just tried cases. We needed a single JA. So we not only redid the way that the civil work was done, limited the number of appearances, we literally set up a schedule where in many cases we don't see you until after the 3-year date expires for serving it, and if it hasn't been served, that means we can dismiss it. I mean, the days of us paying attention to your case are over. We are, in fact, sending you out to litigate it on your own. So that kind of differential case management and the dramatic reduction in the number of fully staffed IC courts is pretty much the way we accomplished a fairly significant amount of the savings.
So I told you we had individual calendar courts, which we really liked. It was a system that worked for us. That's where one judge gets the case and handles it from start to finish. But we didn't have enough staff because it takes how many people to run an IC court, Deni?
3.
3 people to run
In the
an IC court, right?
In the courtroom.
In the courtroom. And so we knew we couldn't do that. So we took a bunch of those IC courts and made those judges purely trial courts. And we gave them 1 staff member. So they had no court attendant, nothing else, just 1 staff member. And that's how we were able to cut down the number of managers and employees that we had and still keep a court open. That trial court became very valuable to us because we don't have enough trial courts to handle all the trials we have. And so these became the courts where all of the trials would be sent to. There were about, by the way, 18,000 PI cases that we brought down into our central district. There's now about 22,000 in those courts, but we've had to add, we added a 4th court not too long ago, and they're asking for a 5th court. As it is, though, if you file a demur or have a summary judgment motion, it may take up to a year to have it heard in one of those courts. Yes, sir?
I don't know if this is true anecdotally or false, but outside of California, one of the anecdotes is that private judging or alternative dispositions for civil cases is big. And I don't know if it's a result of this or your culture. Is that true or not true?
The question is private judging a big deal? He's heard that it's very busy in California. Is it true? The answer is yes, it is true. A lot of judges retire and go into private judging and make a lot of money, if that's your thing. And
Is that because of this? Has this always been true, or especially because of this?
it's always been true. I think this was a boon to them, to be honest with you. If it's going to take, you know, in California, if you were around in the 1970s, it took a civil case 5 years to get through the system. And we knew that. There was articles in the Los Angeles Times saying if it's a race between a civil case and a snail, you'd do wise to bet on the snail. But Then we had some trial court acts that speeded the speedy trial court acts that made the cases move along. And we were down to about 14 months. Now it's getting up there again. And so as the cases take longer in pendency, it becomes more attractive to go to private judging. So yeah, I think that's true. And we also don't have enough judges in California.
One of the things also that was taken away with civil was our fabulous mediation programs that were volunteer and essentially free of charge for a limited number of hours. And that business has also boomed. As the free mediation went away, then the paid mediators came in. So
I'm going to move on real quick because I want to take any questions that there might be. So we have hubs. What we did is we hubbed our small claims courts. We moved from 27 locations to 5 in the small claims. That was about 61,000 cases. On the unlawful detainers, there are about 67,000 cases countywide. We did the same thing. I'm going to sort of speed through this because I want to have some time for questions. So again, we did an analysis of all the cases, how many a judge could handle before we set up these courts. We looked at bus lines, we looked at distances people had to travel. People had to travel up to certain amounts of time. We looked at, this is how we did it. Basically, we did this for small claims, unlawful detainers, for collections. We looked at where the districts were, where the cases were, and then we consolidated those cases and would move them to one courthouse. So, for example, as you look on the chart there, you see that East District, North Central District, Northeast District, East LA Courthouse, all that work went to the Alhambra Courthouse. And so for the small claims, all those cases ended up in Alhambra. We had to move those cases. And in the small claims, it was really difficult because we found out that we had problems with our case management system. Cases in different districts had the same number. How would you like to have to figure out and move those? So we discovered that, but these are the kind of things we discovered. As a judge, could I handle that? No way. I didn't know what to do with that. Deni, we fixed it though, didn't we? Eventually.
With the help of those team leaders and those teams.
The team leaders, the IT people, if they weren't there as a team with us, this could not have happened. I didn't bring the charts, but we had charts showing movements. We had a war room. It would show us when cases were going to be moved, how we were moving the files. You can imagine 67,000 cases to be moved in a short period of time. Often we moved those cases, and the end result was that this is how it was spread around our county. The black dots are where they were. The red dots are where they ended up. And so we moved all those cases around the county. You had to figure out how to do that, and you had to have managers working with you to figure out how to move those cases. Oftentimes, we moved the cases before we moved the employees. Employees that were going to be laid off. And they knew they were probably going to be laid off because they were at the bottom of the list, who were helping us do this in a time of crisis. And I think Judge Jones told you about the collections cases, 80,000 cases to 2 locations. Before they were in 27. You know what? We recently got a letter from the lawyers that specialize in collections cases thanking us. They think it's great. They don't have to drive to 27 locations anymore. They only have to go to 2. So there are things that are happening. Additionally, and some of you maybe have this in your states, if you're not from California, when we hub these cases, there's a big push in the federal government that every single case, civil or criminal, should have an interpreter. We don't have enough interpreters in the state of California to give everybody an interpreter. I will tell you that right now. Okay? But when we hub these cases, and small claims go to 5 locations, we actually can provide interpreters at 5 locations and services, mediation services and other services at these locations that we couldn't do to 27 locations. We didn't have the resources. So there's a hidden benefit to the fact that we consolidated. We couldn't tell when we had blended calendars of one judge doing civil, probate, everything else, because the clerks were all different that did those functions. We couldn't tell how much staff we needed to support that bench officer. When we had the bench officer doing a special function, a complete function, only small claims, we figured out how many staff we needed to support that function. On a court of our size, if you're a small court, it's probably a little easier to figure it out. On a court of our size, it was not easy to figure out. Those were exercises that we worked on with our managers to figure out how much staff do you need to do this kind of work. Now, I'm going to skip over that just to show you the collection hubs and the distance in our county, how far people had to go, but they like it. And again, when you drive this distance in Los Angeles County, what you're seeing here is probably an 1.5 to 2 hour drive to get from one red dot to the other.
Not in traffic, yeah, not during rush hour. It's further than that.
So all of this is easier said than done. I could have thrown out a policy and said to my administrators, and many of whom are here, just do this. Just do this. This is what I want. Just do this. Just make this work. And of course, when it didn't work, they would say, hey, it was your idea, not mine. That is not a shared consciousness of purpose. Or people could have said, sure, it's going to work. Don't worry about it, Judge. Well, it's going to work. That false assurance with no consequence to them wouldn't have helped me a bit. I had to know, because this was my idea, you know, I had to know if it was going to work or not. So I didn't want a false assurance. That was not a shared consciousness of purpose. Or the dreaded false commitment. Sure, it will work, and then turn around and under their breath say, you fool. I didn't have any of that. I had doubt. We all had doubt. Deni had doubt. She told you at the beginning. But they would come to us and tell us what their doubt was and how to fix it. But this didn't all happen. What took 6 months of success really took a decade of planning. Staff trusted us and our leadership decisions. Some of our staff that got laid off, and Deni can tell you this, thanked us for the opportunity to work for the court. Our supervising judges, our presiding judge, our APJ, study and learn about budgets and administration and case management. I know John Gratian is teaching here today. I saw he's a case management expert. I worked with him for several years on case management. We talk about case management. We spend years, and I mean years, cultivating our relationship with our justice partners and county politicians. I had to go to each one of our politicians and talk about these closures. One of our courts is in Catalina, which is an island off the coast. And I was closing that court, and the island, they were very unhappy, to say the least. I was getting emails and nasty letters. But we ended up not closing it because when we really looked at it, there were a couple of problems. One is I was punishing the island shop owners and everything. If there was a theft, they'd have to close their shop to come into Long Beach, across the bay, to prosecute the case. I didn't want to punish them for that. Unlawful detainers and domestic violence cases, we had to have a place for that. So what we did is the court's closed, but every other Friday, staff from Long Beach goes out on the boat and opens that court and works that court. So I went out with the supervisor from that district and met with their city council. They yelled at me, and I made the supervisor a hero by saying, but we're going to keep it open every other week. So now that supervisor, who was always supportive of the court, is super supportive of the court. And that's the kind of relationship that we had. We went to all the supervisors. They all understood the crisis was real. I think every one of our employees knew that these budget cuts were really hurting our court. So there was a certain trust that had been built up over the years. We've had fantastic CEOs, CFOs, and COOs. And believe me, they are admired by all of the judges on our court, and they meet regularly with the judges. So they are not strangers to the supervising judges of our court. We have a monthly meeting with all the supervising judges, and the COO, CEO, and CFO are at those meetings, as well as our head of IT, to answer questions of the judges. We had a 3-year budget plan. We don't anymore, but we did. And we review monthly any legislation that is pending that may affect our operation. So decades of work paid off. That was the underlying groundwork for everything we did. And it really helped. It paid dividends in the end. You want to know how the story ends? This year, we did not get a budget cut, but we got very little help from our governor. I mean very little help. Many courts in the state are still suffering and are going to have to do further layoffs, furloughs, and close courtrooms. But we in Los Angeles have a balanced budget. We are expanding use of technology. We are constantly making improvements to serve the public. I would say too that judicial morale and staff morale is returning. This is what we have accomplished as a team that neither I as the presiding judge or any of our judges could have done or administrators could have done alone. So on behalf of Judge Jones and Deni, Butler, and myself, I thank you for having the privilege to speak with you today, and we'll be glad to answer any questions. I see a question.
I can't imagine with 500 plus judicial officers that all your judges lock arms and say,
You've been to our court.
Okay, so the question is, you can't believe that we had a kumbaya of 550 bench officers. I don't know why you would say that. And so what do we do about that? Well, you know, every court, even a small court, may have an errant judge, and it's very difficult. They're independently elected bench officers. What can you do? But I have to tell you that, and I'm not exaggerating, 95% of the judges on our court wholeheartedly supported this plan. They didn't like pieces of it. They didn't like pieces of it. So no matter what we did, somebody was unhappy. Our judges had individual books. They had their own little libraries. I did away with those libraries because I saved $2.5 million, and it's electronic. The younger judges, no problem. The older judges who are set in their ways, to say they were unhappy is putting it mildly. Judges had assignments that they traditionally didn't do. Small claims, unlawful detainers were traditionally done by commissioners. They are now doing that. So yes, they were unhappy. How do you deal with it? You say, too bad. That's the job of the presiding judge. I'm not there to be loved. My job was to make the court work. You have to be able to say that. I'm an equal, just because I'm the presiding judge, I'm just another judge. The only authority I have is transfer authority, and the authority that I gather from having the confidence and respect of my fellow judges that elected me to be the presiding judge. I rely on that. That's how I got this done. But we had so many judges involved in this project. It wasn't just our few supervising judges. Everybody came to us with ideas on how to make this work. The people that were doing small claims and unlawful detainers in the hubs became teams with an esprit de corps of their own. They really did buy into this. Are there still people that are unhappy? Yes, there are. But there wasn't a judge on the court that didn't know we had a financial crisis and had to deal with it. Because I went to every district, we spent so much time teaching people about the budget. So this was not a surprise to anybody. That's how we dealt with it. You're never going to make everybody happy. Yes?
Thank you, Judge, and congratulations to your team for making this work. I don't know if I could have lived through it.
It was touch and go. David?
Okay, it's sort of two questions. One is, how'd you deal with the unions? And the other is, do we have a centralized HR? Okay, so we have actually a very good relationship with most of our unions. That's another part of this decades in the works. And so one of the sellings was the unions had understanding. Actually, this was done by Deni and our senior management staff. They talk to the unions. The PJ in our court does not talk to the unions. Although I know a lot of the union leaders because they used to come to meetings that I was at, and I was very supportive of them. And they knew this was a real crisis. In fact, SEIU was fighting to get more money for the courts. It was, after all, their employees that would lose because of the budget cuts. 80% of our budget, like most other courts, is personnel.
So can I add one?
Yes,
couple
go ahead,
things?
Deni.
So one of the things Judge Wesley mentioned was, this was a really intensive 6 months, but part of its success was the 10 years prior. And building those relationships with the unions, which we had done very successfully. Our CFO is very well respected by our unions, and he gives fairly regular budget updates to them. So again, the fact that we had a budget crisis was not news to them. what we had done to deal with it, where we were spending our money, all of those kinds of things. It was all pretty much laid out there for them to see. So when you get to the bottom line of this is where we've spent the money and 80% of it goes to staff, they recognized that it was going to be staff changes that was going to drive this picture. And so it was the transparency, the same transparency I think that helped with the judges. They understood that we had a problem and we had run out of options. So it really was, it was just sending the same message for a very long period of time.
And with respect to the HR, it's the same kind of relationship. The head of our HR is a lawyer, a very brilliant lady, and her name is Yvette Pena. She's a Harvard Law graduate. She meets with us all of the time. Before I make any decision on employee matters, I talk to her and get her advice. And I think that's the way it's always been. And she knows all of the SEIU leaders. But employee issues include my commissioners and my referees. And so I would go to her. So we offered a fairly complex voluntary separation program from our court. And I know other courts are struggling with this around the country. What do you do with, they call them adjunct judicial officers. And what do you do? On our court, commissioners, which are adjunct judicial officers elected by the judges, are at-will employees. But there was a history of never firing anybody. And so those are all issues that we talked about with the head of our HR. So it was a good question. But we have one person that we go to, and she runs that department. I see a couple more questions. So over here in the corner.
Yes, I wonder if there's a relationship between the unification of the court system and the budget crisis. I wonder what you did with public access when you started having the courts, for the average court client, that might be confusing because they come for a variety of reasons. And I wonder in that regard then, how did you inform the public? I know that within your system, it was relatively easy to get that information out to frequent court users, and less frequent court users seems to me to have been a challenge.
Thank you. And let me repeat your question starting from the last first, which was, when you are changing where the new filings are going to go as well as existing filings, how do you get the word out to everyone, because many of these matters are self-represented litigants, that there will be changes and that they will be taking place, was question number one. And then the earlier question involved access, physical access.
If there's a relationship at all between the unification of the court system and the budget.
I'm going to hold off on that one piece and just talk about the access and the notice. One of the bigger tasks of all of these various teams were to inform stakeholders as to what was happening, stand quietly while they barraged us and berated us, knowing that we had to do this. This was very disquieting to a number of stakeholders who had business models really structured about, this is the courthouse, this is where I run my business, and now you're moving my business across here and I don't have an office there. I divided the world with my competitors long ago, and they have that courthouse and I have this one. So there were fiscal motivations, there were true access difficulties. We were asking people to travel very long distances to be able to make personal appearances in courthouses far away from their home courts. And letting everyone know. And this was part of everyone's action plans, included town hall meetings, included going out to every single group that we could talk to, public notices on the website, public notices in the courthouses. We had to give notices of the courthouses we were closing physically on the building, saying this building will close, you need to go to X, Y, and Z with maps. And I recall within about the first week, everyone was going to the right courthouse. For about a week, we had I went to the wrong courthouse, but literally it was a problem that resolved so quickly, we were thrilled.
This was an issue we recognized and worked on. We had a lot of discussions. Deni, you want to add anything?
I just want to say, the public notice, I'm visualizing what's in my office. The public notice book that we posted on the web and at the courthouses, that book alone is about 2 inches thick. There were a lot of notices.
We specialize, Deni and I specialized in notices. There are a lot of required statutory notices, but also public notices, all kinds of things went out. With regards to whether or not it's still what we'd like, no.
Well, and I can answer your unification and
feel free.
consolidation plan, they're exactly the opposites. Unification unified the municipal and superior courts so that you would have general jurisdiction courts where only municipal courts existed before limited jurisdiction courts. So it was to provide services to neighborhoods across the board that weren't there before. Family law court is a general jurisdiction court. Not every district had family law courts, but with unification they did. And they did felonies. They did things that weren't done around the county. Consolidation, just the opposite, is we can't provide those services. We don't have the staff to do it. So unification, that was part of our largest neighborhood court in the country program. We liked that idea. That was our vision of a court. So if that answers your question. In the back.
So if I understand correctly, you have sort of a hybrid system where some judges have individualized calendars and some are on this master calendar system where they just
Correct.
have one single
Correct.
issue. Is that correct?
Correct.
Do judges get to choose and do you have to assign judges? I mean, how unhappy are judges with being put on a master calendar system if that's not what they want to be on?
Too bad. But no, but
Believe it or not, okay, so the group that remain more intact in what they used to do are the unlimited civil judges. There are very many fewer of them. The unhappiest group of judges are the people whose assignments didn't change because, frankly, they got a ton more cases. They can't manage them the way they'd like to manage them. Things are getting slower. They prided themselves in their very hands-on case management techniques. Those are increasingly challenged by the size of their calendars. So if I had to do an unhappiness meter, ironically, it's probably the people whose assignments changed the least in terms of the job they were doing.
and from a rules standpoint, all assignments, I'm the final arbiter of all assignments on our court. And
But
the
they
way I
still
do
don't want to
it,
change their assignments, so
Yeah.
they might be unhappy, but they're not asking to change. The ones who went into the new configurations, we teamed them up. This was also sort of a novel idea. Because we were putting so many cases into these hubs, we were concerned, even though we had built it on a single judge model, it was the Uber judge model, and we were concerned that we had simply created a burnout court that no one could sustain over any kind of period of time. So we put a shared bench officer setting in those hubs. And so most of those hubs are staffed by multiple judicial assistants and 2 judges. And they work as a team on their caseloads. Either someone takes the morning, someone takes the afternoon, or they take half of the workload and divide it in some other configuration. And over those, what we call hubsters, we created a supervising judge of hub operations, and she has created enormous group pride and unity. They have a hub conference call. They deal with hub issues. They deal with subject-specific issues. And it's created an amazing esprit de corps. Some of the happiest judicial officers on the court are in those hub operations.
we haven't had a lot of movement over the last years because we're down so many bench officers. And so because there's no backfill, people don't move, but they know that. I mean, we're pretty upfront about that. Again, I have ultimate assignment authority, but I don't make assignments just like that. I talk to the supervising judges, who's best for this slot. We talk to the judge and try to convince them it helps the court, it's a need of the court. And most of them, and to answer your question, most people buy into it. And they're there to help the court, especially new bench officers. They'll do anything you ask them because they're so excited to be a judge. So I'm going to give them the assignment that they'll do anything you ask them to do. But even our senior judges, like I told you, our senior judge in Beverly Hills has been with our court over 28 years. She's doing traffic. She's doing 118,000 traffic cases, and she has a smile. I went to see how she was doing. She's great. So there's always going to be unhappy judges. That's always that way. It'll never change. There's always going to be problem judges. It never changes. At a court of our size, we have problem employees. We have problem judges. That just comes with the territory. Was there another question? I saw one more. Yes, sir.
So in Wisconsin, the legislature has imposed budget cuts in the last 2 bienniums. In the one previous to this one, the court's absorbed. In this one, the court is on the verge. In fact, I'm waiting for notification that they're going to tell the legislature to go pound sand. They're not going to be able to meet the cuts, and there will be something to the effect of a declaratory judgment to say you will fund us at some sufficient level to make us whole and get us one more job. So my question to you is, was that an option for you?
It sure was.
Was it considered?
Oh, yeah. Oh, yeah.
Oh, yeah.
Oh, yeah.
Oh, yeah.
We're lawyers. We went there first.
Actually, we did go there first.
We did go there first.
But I can't say that. That has to come from the Chief Justice of the state. And our Chief Justice isn't willing to do that. I will tell you right now. Was that suggested by lawyers, by judges? You bet. And in fact, I have a file full of cases around the country where they've tried that. Actually, not too successfully. But I think it's a constitutional crisis. Our Constitution in California says you have to fund the courts, they have to be operable, and our governor keeps saying, I want you to find elegant efficiencies. I don't know what an elegant efficiency is, but he says find an elegant efficiency. I'm still trying to define that. So we have the same problems. In the meantime, you're going to want to make your court work. And if you don't get the money, you've got to figure out what you're going to do. We planned on not getting the money. We balanced our budget. Are we providing the kind of service we want to do? No, we're not. But we're still open and running. And like I said, morale's improving. We're embracing technology. We're moving forward with a smaller footprint in our county. And we're just living with it. Thank you all.